First off, I'd like to thank everybody for being in this room today. It speaks volumes that, well, hi Lisa, how are you? That I know somebody is not a bad thing. I appreciate everybody that is in this room to expand your horizons and learn things. Knowledge is power, and the more you know, the better job that you will do. And that's what all the instructors over the last Friday and today are hopefully giving you that knowledge to better do your job. So again, I appreciate it, as do all the instructors, I'm sure. I just want to give you a little background on me and the program, then we'll kind of get into the nuts and bolts of it. I was hired by the city a year and a half ago, and again, my name is Dale Wood, just like it sounds, real simple, single syllable words there. I was hired by Beth in December of 2009 as the second person in this position. I work for code compliance. Polly, I think you met her last week, only my area of expertise in what I do is occupancy investigations. And to put that in perspective, I got a couple of numbers for you. There's about 3,500 state statutes on the books of the state of Colorado. There are about 200 traffic laws that the Fort Collins Police Department and every law enforcement agency enforces. There are probably about 50 municipal ordinances that our PD enforces, and there are 18 nuisance ordinances that my peers enforce. The city hired me and pays me to enforce one ordinance. That's it. That's how important it is to the city. All I do is occupancy investigations. In the summertime, when I get the investigations down to a fairly low level, I may help out the nuisance people, but the focus of my job is to enforce just one ordinance. So the city takes it pretty seriously to pay my salary to enforce one ordinance. Now, a little bit of background on myself that got me into this position. I am a retired law enforcement officer, 31 years, actually retired as the chief of police from a community in southwest Colorado. And when this program started in 2007, it became apparent that the area of expertise needed to be something along the lines of investigations and not building department related and associated, if you will. Henceforth, that's how I was successful at getting this position. And I think it's been a good fit. I've had a heck of a good time, and not having to wear a uniform, and I think the world of Susan and her peers, but I like the position I'm in now. So it's been a really good fit for me. This particular ordinance, the occupancy ordinance, was originally enacted by City Council in 1964. It's been around that long. It was originally written as a criminal ordinance, which in general terms means somebody can go to jail if you violate a criminal law. Well, that's ridiculous. Who's gonna go to jail? Who would take somebody to jail for having too many persons in a house? So it was virtually unenforceable because of that. Due to public outcry in 2005, the then sitting council rewrote this ordinance as a civil ordinance. There is no possibility of any jail time in a civil type situation. So that took that criminal element out, put a pretty healthy fine attached to it that we'll talk about in just a minute, but put the teeth into it so it was actually an enforceable ordinance. The enforcement started in earnest in 2007, and I took the position in late 2009. So now, instead of somebody going to jail, which never happened in the first place, a person that violates this ordinance is subject to a $1,000 fine, and that's per day, and that is per occupant, per landlord or tenant, and per owner. So if I have an over occupancy of five tenants in there, it's supposed to be 3, they're all potentially culpable. We have one of you individuals managing the property for a distant owner. So we have 5 tenants one property manager, one owner, that's $7,000 a day. I could make the budget for the city of Fort Collins if Beth would let me do so, but that's not the intended purpose of the ordinance at all. That's the hammer, the tool of last resort we use, not the first resort. What we're after is compliance, and the compliance is obtained by educating you and the tenants. And I know that CSU has a significant outreach program to educate the upperclassmen as they're leaving the campus to not over-occupy, be aware of the ordinance, but I think everybody in this room knows it exists. I can drive around this city and start pointing out properties that are clearly over-occupied, but the program is complaint-driven only. We want impacts in the neighborhood felt by neighbors and other residents and people around there to report the violations to us. I do not go out and proactively patrol and look for violations. And there's a couple of reasons for it. Number one, we don't want to do it. City Council doesn't want us to do it. We want the negative impacts to be the driver of this, but the caseload is pretty significant. 140 cases the first year that it was enforced, which was 2007 again. Then 2008 and 9 hovered around 60. Last year was 104 cases, and for 2011 we're setting up for another year of 60 to 70 probably. And right now I have 14 open cases that I'm actively investigating. In the last 2 weeks I've issued 10 citations to tenants, 5 in 2 different homes. So there's not a whole lot of time for me to be proactive with the amount of complaint-driven caseload that we actually have. The largest fine that the city has assessed to date is $12,000. And that doesn't mean it couldn't be more. As a matter of fact, I have a case right now that potentially is going to be in the $20,000-ish that I'm still collecting the information, and potentially an owner and landlord is potentially facing a pretty significant fine. He put 6 tenants into a property that he presented as a duplex, and it's not a duplex. It's in a zoned area that would never allow duplexes. And he knowingly put 6 college students in that house. So my suspicions are we're going to hold him pretty accountable for that. So we've all heard 3 unrelated or U+2. Has everybody heard those phraseologies? I don't use them. I take the language right out of the ordinance, because the spin that is on those, particularly from students, U+2 or 3 unrelated, they're descriptive, but they're not necessarily accurate as to what the ordinance says. So I'll give you this real quick. And when you have questions down the road, please don't hesitate to call me, because it took me sitting with Beth for 2 months to figure out the application of this ordinance and the formula. And I have a pretty good handle on it now, but the first couple of months I was in her office every day. Okay, Beth, what happens if you have this, this, and this, and this? But I've got a pretty good handle on it now. There's 2 sections to the ordinance. The first one deals with families. A family is blood, marriage, adoption, fostering, any other component that you can legitimately call a group of people a family. You can have the family plus 1. So it doesn't matter how big that family is. The family plus 1. The second part of the ordinance allows an adult, their dependents, a second adult, and their dependents plus 1. So you fit into one category or the other. Occasionally I'll have like siblings, brothers or sisters, brother and sister, a cousin and a cousin, wanting to try and manipulate the ordinance to get more than the plus 1. So what we do is apply the second part of the ordinance. Okay, if you don't want to consider yourself a family, now we have 2 adults, but you have no dependents generally because you're college kids. You still have the +1. So the 3 unrelated is somewhat accurate, but not entirely accurate. Same as the U+2. The U+2 has nothing to do with the family component. So all these descriptors have to do with the second part of the ordinance. So family +1, no matter how big this family is, they can have +1. Or 2 adults with dependents +1 more. So that's the easiest way to remember it, and you'll not even refer to the cute little acronyms, because they're descriptive, but they're not accurate. In your notebooks, I think you have this document here, fairly important document. Occupancy disclosure statement for lease. There's a nearly identical document that is properties for sale, but for our use here, if you can find this document, we'll discuss it really quickly here.
Landlord tenant handbook, but it won't hurt to have another one, so I will
Okay.
pass those out.
Yeah. Did I get them back from you there? Oh yeah, here we go. This document was rewritten last year and was approved by City Council and went into effect on May 13th of last year. If you have an older version that does not have the shaded area, I would recommend that you discard those. It's no longer a valid presentation of this document, and the reason being is we now require some type of date that can be authenticated on this document. What we were seeing is the vast majority of disclosure statements were corrupted because they weren't executed at the time of lease, and it makes it difficult for the investigations if we cannot determine that the tenants and the landlords were all on the same page as to how many bodies could be in that property. So the shaded areas is notary blocks. We recommend that you not get them notarized. That seems like a whole lot of work to us, a whole lot of work to you. But you can get them date stamped in any reasonable means possible. You can fax them, not to me. I only want them if I request them in an investigation, and I get 1 or 2 a week anyway. But I don't want them only if I request them. But you can scan them, save them. That'll put a date on them. You can put them in the body of an email. Capture the document, the Word document, put it in the body of the email. Just like any other email, it's going to be dated and timed. So that's all we require, is some type of a date stamp. So when I get this document, then I have X date down here, there should be some consistent date that is electronically placed on the document. So I can say, okay, this was in fact executed 9 months ago and not 9 minutes ago when the landlord got the notice from me to present this to me. And the ordinance allows me to collect this document, the lease, and any financial records you may have of transactions between the tenants and you. I don't always collect all of those documents, although I've had to call Lisa a couple of times, and when she hears it's me, the fax machine is ringing, and I'm getting the documents before she even gets on the phone. But the faster that we can start an investigation, the faster that we can get it resolved. We can get that occupancy load down to the legal limit of 3. Does anybody have any questions about what I've talked about or this document? Yes, ma'am? Did everybody hear the question? She wants to know if I'm trying to remember to repeat the question there, Jenny. Is she liable if she executes the document, puts 3 individuals in there, and then they were to violate the ordinance? The investigation, the purpose of my job is to determine who is in fact culpable in the situation. Is it the tenants? Did they sneak bodies in under cover of darkness, so to speak? Or did the landlord knowingly and intentionally put more in there, only not show them on the lease, or show them on the lease? Occasionally I see these documents with a 4th name added at the bottom, even though it's very clear tenant 1, tenant 2, tenant 3. But the purpose of my investigation is determine who's responsible. And then we hold that person or persons responsible.
So what more can I do to show that I did not intentionally?
Probably absolutely nothing. There's nothing that you can do other than cooperate with me during the investigation, and we'll find out who's responsible. And I don't want to say more times than not it's the tenant, but more times than not it's the tenant and not landlords or owners. Yes, ma'am? You bet. The question is, on an annual walkthrough, is there evidence of more than 3? So a violation of this ordinance. If you want, you can call me. I'll be the bad guy. That doesn't bother me at all. And we get lots of internal complaints, if you will. They're not all external, but I'll get complaints from landlords, owners, and tenants when they want to report. So you can report it to me. I think you should probably start the eviction process, but that's an attorney question.
Right.
But
dealing with you would be faster than the eviction process?
Absolutely.
So you know that there's more.
A whole lot pain and consternation and cost to you. So, and I recommend landlord tenants to call me. Let me be the bad guy. I'm not opposed to it. I'm going to expect you to follow through and assist me in bringing that occupancy load down, but because it's a collaborative effort. But do not hesitate to ever call me if you see that. And those investigations go pretty quick. And when we issue citations in the thousands of dollars, the kids, if they are kids, and I'm not trying to profile here, this ordinance was not written because of student over-occupancy, but the reality is the vast majority, 85-ish% of the cases, are students from either CSU, Front Range, or both, living in the same house. Yes, ma'am? That is a good question. The question is, when does a guest become an occupant or a resident? For purposes of our ordinance, and the students, they just don't get this. The ordinance states if you stay 30 nights in any 12-month period, you're now an occupant. They don't think they're occupants because they bring in their backpack and their clothes in every day. But 30 nights, and it doesn't take long when you're sleeping over at the friend's house to burn up 30 nights. And that 12-month period is fluid. It's not a calendar year, it's not a school year. 30 nights in any 12-month period. So you might emphasize that to your tenants, because that it catches them all the time. I get into the investigation and I'm talking to the primary tenants. There's usually one body that is more responsible in the house than the others. I call them the Speaker of the House. And the Speaker of the House and I will communicate, well, Joe's only here 3 days a week. Well, let's see, 30 divided by 3, I think, is like 12 something or 13. So there's not many, you're not there very long before you're in violation of the ordinance. So boyfriend, girlfriend stayovers is chronic. And like I tell them, I'm not the bed police. I don't care who's sleeping where. What I care is what that occupancy load is, which is 3. Did that answer your question? Okay. Yes, sir? The question is this form required if you have less than 3 tenants? This form is required by ordinance every time that you execute a lease. And I got another response for you on that. I see lots of leases where this information is embedded in the lease as a bullet point. The ordinance requires this document that I'm holding in my hands, that all of you have, this document, not a version of this document, to be executed. It's a standalone document, just like the lead-based paint document. It is an addendum to your lease, not to be embedded in it. And there's a reason for that. We want your tenants to know what they're signing, that you can have 3 bodies in there. And if you put 4 bodies in there, we're going to hold you accountable. So that's the reason we don't want it embedded. It's that important to the city. Okay? I have another thing I want to talk about that we never have before. But over the last year and a half, I have found the need to get the education out on this, and this is the rest of the documents that you have. Everybody's probably heard of the boarding house, the permitted boarding house. That's old language. Now it's extra occupancy rental homes, not over occupancy. Over occupancy is a violation. Extra occupancy under permitted circumstances is permitted. So we're going to talk about extra occupancy rental homes. And you have one flyer, the one handout, extra occupancy rental homes regulations. That's put out by our zoning department. There are 15 zones in the city that allow extra occupants in a home, and they're listed in this document. And I can't remember all the acronyms and what they all stand for, but there are 15 zones. And did we hand out a map too, Jenny? The map that's yellow in color, with the exception of the block is CSU, which is bright yellow. Those are the zones in the city that allow extra occupancy, so you can put more bodies in there. But there's a few stipulations that you have to meet, and you can read it all in that handout, but I'll kind of cover them. This isn't my area of expertise, but I get involved because I run across it, and if a house is in the proper zone and they are over-occupied, I will assist the owner in getting the proper certificate of occupancy to make it an authorized extra occupancy house. The criteria that needs to be met: the house has to be a certain square footage per body. There has to be adequate parking, and the formula again is in there here, and I can't quote it off the top of my head. And a certain zone requires a maximum density on the block face, the LMN zone. Low density mixed use neighborhood, I think is what that stands for. You can only have 25% of a block face. So from Avenue A to Avenue B on Oak Street, that's a block face, 25% of the homes would be eligible for extra occupancy. So here's the catch. In the city of Fort Collins, which I think with the last population study that we just had done, the census in 2010, 143,000 people-ish live in this city. There are only 36 extra occupancy homes in the city. That's it. If I was an investor, if I had money to invest, I would go out and seek out these homes in these zones, get them approved, get them CO'd with the city, because the demand to put four, 5, 6 bodies into a home from the campus is just unbelievable. But there's only 36, and I've helped get 2 of those approved since I've been here. When I started, there were 34, and we've approved 2 in the last year and a half. So if you have owners that have rentals in these zones, if you go through the process, you can qualify for this program. But it's very specific. It's a zoning that's on the map there, and it's not uncommon to have the one side of the street one zone, one side the other, and you can have them on one side of the street and not the other. I didn't draw the lines. I just pass the information along, because I get people wanting to know, well, why can't I have it when across the street I can? Well, I can't answer that question. You'll have to go to the zoning department and find out why the boundaries were set like they were. But this is an underutilized program that we would like to see it more utilized, because it would have an impact on the over occupancy. If we can get the bodies into a legitimate extra occupancy situation, we would have less over occupancy problems that we deal with. So I'd encourage everybody to look into that. Yes, ma'am? You're just loaded with good questions. Boy, oh boy. And the question is there a process for exchange students to over-occupy a home? And there is another document I didn't bring because I did not think we would have time to, but this class is usually 40+ people, and the questions are rapid fire. So but I'm prepared mentally, I just don't have the handout. We do have a program that allows extra occupancy anywhere in the city, but there are some criteria to it. The home has to be owner occupied, cannot be a standalone rental, like an investment property. Has to be owner occupied, and that's the hardest, the most difficult component to factor in. It's called, it's our host family program. So if some of the churches need to have, like missionaries stay over, exchange students is a good example, and an unintended consequence is if it's owner occupied, pretty much anybody can put an extra body in that house. So instead of having your family plus one, you can have a family plus two. But there are some pretty significant stipulations. You can't have prior violations of this ordinance, the occupancy ordinance, or any issues with the ordinances enforced by the PD and code compliance. So you got to have a pretty clean background for the property. Again, it's got to be owner occupied, and the permit is valid for a 10-month period only. And the purpose of this, when the program was implemented a year ago, was for school period, the period that higher education is in class, if you will. So conceptually, an individual could qualify under the host family permit program, occupy a place, say August to June. But you have to have that 2-month break, because we do not want it to be an over-occupied situation. That's why we require the 2-month break. But then 2 months later, you can put that extra body in again. Got to have that 2-month break, and it has to be owner occupied. I've run into this a couple of times where and I did this, and it's more popular than I ever thought. When my daughter came to CSU, which brought me to Fort Collins, by the way, from Telluride, was my daughter came to school here and never came home. So my wife and I said, well, we're going to retire and we'll chase her up there. She can't get rid of us that easy. And that's how we ended up in Fort Collins. When she left campus as a sophomore, I bought a townhome in lieu of paying somebody else's rent. And I thought, man, this is a good idea. I wonder why nobody else does it. Well, what I found out when I got this job is everybody does this. So I'm not as smart as I thought I was. But what I did was put her and her cousin in there, two people. I was aware of the ordinance when I signed all the paperwork, but I had no intention as a distance homeowner of even putting 3 in there. We did it for a positive learning environment for the kids. I didn't want 3, 4, 5 bodies. I wanted 2, my daughter and her cousin, and it worked pretty well. But here's what I find almost every week I run across this is people will do like my wife and I did and purchase a property but only put it in the child's name, the student's name, their adult child, 19, 20-ish something, or not. Generally they put it in their name. I put it in my daughter's name because of the kind of loan that we got. So our city attorney's office's opinion, which I support, if it's in the parent's name and not the child, if the child's not on the deed, on record with the assessor's office, it's not owner occupied. Now, if that child's name is on the deed, like my daughter's was, then we would have qualified for a host family permit in that situation. But more times than not, they don't put the child's name on it. Henceforth, it's not owner occupied. And I've run into that repeatedly. So kind of keep that in mind if this is something that you all get exposed to. So that program does exist. It's out there. I have 4 permits out there right now. It's only been in place for a year, so we're trying to get it out that this does exist. But the big criteria is that 10 months. From the date that 4th person is in that property, you got 10 months. That's it. So if it starts today, you're not going to make it to the end of school year next year. You're going to be out 2 months ago. So would that be in February of 2012? And again, it's very specific. It was written, drafted, and approved by City Council to allow exchange students, religious missionaries, those types of situations. And it's a good program. Yes, ma'am? Or sir, I'm sorry. Yeah, okay, the question is, if you vacate a property and then put it on the rental market, what obligations do you have to the city, basically?
Say it's in a residential district, it's a standard lifestyle home or whatever.
Okay,
Can I rent that, or do I have to have the city inspect it before I rent it and leave town?
okay, so does that property, once you vacate, put it on the rental market, is there a requirement from the owner to have that inspected by the city? Is there any cost to the owner as far as permits? There is no registration or licensing of rental units in the city of Fort Collins. We're actually kind of opposed to it. Beth and I have made presentations to city council why we don't want to do that. There is no requirement. The $400 fee that you're talking about, I think, as this individual pointed out, a program that is ending in June of this year, that was in place for 2 years, is unapproved dwelling units that basically duplexes, if you will. The city had a grandfathering period of 2 years, which is ending, where they waived a whole bunch of fees, particularly if you got at the front end of this thing. You could get a unapproved dwelling unit into an approved dwelling unit, meaning a duplex or triplex, something along those lines, for virtually no cost to the city. A little bit, but not like it's going to be after June. And the cost has gradually grown over the 2 years. It was a graduated back to the normal fees, which this grandfathering goes away like June 16th or something, right, Beth? I think something like that. I know it's middle of June. The exact date escapes me.
Well, Mike will be here at 10:30 and he can cover a lot of that.
Okay, so you'll hear that shortly, and that's unapproved dwelling units. But to specifically answer your question, there is no inspection required to put it on the rental market, and there are no fees associated with the city to actually own a rental. If an owner occupies the property and you have 2 tenants, say to help with the mortgage or whatever the case may be, or just for additional income, is there any permitting required for that? The answer is no, because you have the 3 unrelated. Make sure you execute wherever that document is, because you have 2 tenants. So we want to get this document executed when you do that. But there is no other requirement. It's an owner-occupied rental, which is very common.
Dale, can I qualify though?
Uh-huh.
If you are, if it's you and your wife and child, and you want to rent to 2,
No, you can rent to 1.
so if you're a single person owner-occupied, then you can take in those 2.
But if you, and Jenny's entirely correct.
Family, say upstairs, and 2 people downstairs, it can only be 1 person upstairs.
That's correct. The ordinance was actually written as a response to that, to prevent 2 family units from occupying one dwelling. So that's a purpose of a family plus 1. Very, very, very specific. You can have what would be considered two family units there. Then you have an absentee homeowner that's not even around to manage their property. And I run into that all the time. And what I tell the owners or property manager, I want to put the word manage back into property management. It's not my job to manage these properties. I investigate them. But if they were properly managed, we wouldn't have some of the problems that we do. Okay, I've got 5 minutes left. I know that it was quick and we covered a lot of material. Do you have a question? Okay, we're going to clarify the ordinance is basically what we're going to do here. Again, you can have the family, any size of family, whatever that definition means in that particular scenario. Aunts, uncles, nieces, nephews, cousins, it doesn't matter. If you're family, you're family. You can, so if there's 20 members of that family, they can have 1 non-related person occupy that property. The second part of the ordinance, and I think this is where we need to clarify a little bit, you can have an adult, their dependents, so their minor children or elderly care, any person that legitimately is a dependent of that party. An adult, their dependent, a second adult and their dependents, plus 1. So what you cannot have is adult dependent, another adult, and dependents. That third person in every scenario is a standalone person, can't bring any baggage with them. Mm-hmm. Lisa. Uh-huh.
So we've had 3 or 4 before,
Yeah, absolutely.
I'm just curious
Yep.
if it's the old form.
The question is, what's the deadline for this particular format of the disclosure statement? Because there's like 2 or 3 prior to this. What we ask is, from this day forward, for all of you, execute this particular document, not the ones with the geese flying in the corner, you know, the old city logo. I see those occasionally. And then there's one with the newer city logo, but does not have the notary blocks on it. So if you have any that does not have the shaded area, that's an old form, so don't use that. So as long as you're phasing these in now, that's all you need to do. Yeah, I'm
Gonna get in trouble.
no, no. Have you ever gotten in trouble for me?
No, it's been all right.
And
Curious.
yeah, no problem at all. And I am still seeing some with old dates coming in that was in fact executed before May 13th.
Yeah.
And we're real lenient. If I get the information on the document and it's not date stamped, I just notify the whoever it is. Next time you get these executed, get that date stamp on there.
Good to know. Okay.
Okay, let me get hers and I'll come back. Each one, and the reason is, the question is, does each block, there's 4 notary blocks on this form. The question is, does each block have to be notarized? The answer is yes, and the reason is we want tenant 1, tenant 2, tenant 3 to understand how serious this is. But we prefer them to be date stamped, so you don't have to do that.
Yeah, I was gonna say, we didn't have to do
Yeah.
date stamp.
Touchstone's done a really good job of getting these done for us. Yes, sir?
You're talking for the city. What about the county? Is there any requirements?
The
there?
county does not have any occupancy regulations in place. So yeah, we're city limits. Occasionally I'll get a call outside the city, but this ordinance only applies within the city limits. So let me further that. I just closed an investigation recently, a fairly involved investigation, where the offending house was on a block where the city limits took in just that house. And there was a reason for it that's pretty complex. So the complainant, before we annexed this area in southwest part of the city, was in the county. So they waited until the annexation plus a little bit more time to report to us. The violation was in fact occurring inside the city by the way the city limit was driven. So even though the complainant lived outside the city limits, they could have called me a year ago. They didn't, but they could have. So as long as the violation is within the city limits, then we have jurisdiction. The question is electronic means date stamping on this form here. The easiest way, if you can do it, is to scan it, email it to yourself, or you can fax it, and sometimes that's complicated. I think that's why I get the faxes, and then we'll fax them back. But we don't want to do that. The city only wants to see this form if we request it from you. So any means, and Beth, correct me if I'm wrong, when we did the research with the realtors, there are online services, if you have no other means, and I can't tell you what they are, but they're on there, that you send the documents, they electronically stamp them for you, and then we'll send them back to you, and then the cost is like next to nothing. But we think it's easier to do it by scanning, or you can take this document, embed it in the email, not as an attachment, because it won't get the date. As long as it's embedded in the email, then you're going to have all that header up there with the date and the time on it. So that's all we're looking for, is something, and we know that it can be manipulated, particularly a fax machine, but anybody that's going to go to that amount of trouble to go into their memory on their fax machine to manipulate this document and get it back to me, we're going to figure it out anyway. It doesn't take much. Yeah, I've got one more question, then I need to wrap up here. Oh, same question? Okay. Well, thank you very much. Again, call me. Here's my card. I take all calls. I answer all questions. And I'm sure we'll run into each other sometime down the road.
Hopefully
Oh, I hope so too, but I'm not that optimistic. Yes, yeah, please call me, and I'll answer all your questions. And I'm sorry it was fast and furious, but you got a lot of other material to cover as well. Thank you.